So as promised, with a couple of minutes of delay, which I once again apologize for, but sometimes, like I said, things don't go as they're planned in this House. It's rather the rule than the exception. But I would very much like to welcome you here today. And on behalf of my colleagues, MEPs Virginie Joran, Ivan Sinčić, Mislav Kolakusic, and MEP Christian Terhash, who asked to be excused today. He had to tend to a very urgent matter. But I would like to welcome you to today's conference on health and democracy under WHO's new proposed rules. And I would like to thank you for taking the time to come and sit in today. But most importantly, I would like to thank our panelists. They are all renowned experts in various fields who have put in a tremendous amount of time, effort, wisdom, and expertise to shed light on the despicable plans of our democratically elected governments to undermine freedom, democracy, and the rule of law. Each and every one of our experts is committed to one goal and one goal only, and that is to serve the people and to fight for freedom, democracy, and the rule of law. They utilize their knowledge, their expertise by exposing how our democratically elected governments are about to replace the very foundation of our democracies, which is the rule of, by, and for the people, with the rule of, for, and by globalitarian misanthropists, and thus transforming our democratic societies into totalitarian regimes. But enough from me today, because it is going to be all about the experts. So please join me and my colleagues in welcoming the experts who took the time, who put in all of the effort, and thanking them for their commitment, their courage, and their determination to uphold freedom, democracy, and the rule of law. May it always live forever. Thank you so much. At this point, I'm sorry, I will immediately pass over to Philip Kruse, who will sort of like run us through the program. And like I said, it's all about the experts and not about us MEPs today. They are the ones, they are the heroes of this meeting today. So thank you very much.
Thank you very much, Christine Andersen, the MEP here in the European Parliament, the spokeswoman for this brave group of members of parliament who are seeking to uphold democracy and the rule of law throughout the past 3 years and have exposed themselves here in this house so many times. So I thank you very much for this invitation. And in the first round of our expert panel, I would like to welcome here on this panel my colleague from this legal board. Please join me.
Good afternoon, ladies and gentlemen. It's an honor to me to present my dear friend, lawyer Philip Kruse from Switzerland. He's going to be the first speaker of the first panel. And may I introduce him to you now. Philip Kruse is a practicing attorney at law from Switzerland, specialized in tax law. He is co-president of the Swiss Lawyers Committee and founding member of the International Alliance of Lawyers for Fundamental Rights. Philip has led many court proceedings against unconstitutional corona mandates in Switzerland. He has submitted a substantial criminal complaint against Swissmedic for permanently violating all applicable Swiss regulations when authorizing and promoting experimental and dangerous mRNA-based gene therapies for the entire population. Philip will summarize why WHO's extension of powers is the biggest threat for member state sovereignty, for the rule of law, and for democracy as a whole.
Thank you very much, Maria. And it is my honor and privilege to introduce the rest of the board here with me, who have done some tremendous work in the past 3.5 years as well. So right next to me, we have here Professor Michael Geislinger. He is retired professor of international law at the University of Salzburg and visiting professor at the Charles University Prague. And Professor Michael Geislinger, he will explain that the EU had no competences for creating the European Health Emergency Preparedness and Response Authority, HERA. Then, next to us, we have Dr. Renate Holzeisen. She is a practicing lawyer in Italy and an economist, practicing before the Supreme Courts and specialized in European and international law. She was always engaged in issues regarding fundamental rights and freedoms. Member of the Board of Children's Health Defense Europe and president of the Italian Lawyer Association Confederazione Legale per i Diritti dell'Uomo. Currently, her efforts are particularly concentrated in pointing out the brutal breach of the European medicinal law in the authorization procedures of the EMA and European Commission of the so-called COVID-19 vaccines. She filed in February in the European Court 2 actions for annulment of the market authorization by the European Commission of the 2 MR substances Comirnaty of Pfizer-BioNTech and Spikevax of Moderna. Renate will explain to us the extent that the EU has already widely anticipated WHO's project for enlargement of its power to the detriment of the EU member states, and that already today has assumed to a wide extent the power to negotiate the new WHO legal instruments. Then, on our board as well, Dr. Beate Pfeil. Dr. Beate Sibylle Pfeil is a German lawyer and researcher specialized in issues of national minorities in Europe. She studied law at the University of Heidelberg, passed the second bar examination in Freiburg, and holds a doctorate from the University of Innsbruck. She was the Deputy Scientific Director of a South Tyrolean Research Institute in Bolzano for between 1999 and 2016. From 2017 till 2023, she was a member of the Committee of Experts of the Council of Europe Language Center. From 2018 to 2023, member of the Council of Europe Expert Pool on Protection of Minorities, and from 2017 to 2022, Vice Chair of the European Center for Minority Issues in Flensburg. Dr. Beate Pfeil will explain why the concept laid out in the 2 WHO instruments can lead to a quasi-institutionalized human rights violations or to a permanent undermining of the rule of law principles. So I may now start with giving you a brief introduction of what is the plan and what can be seen today from the documents that are on the table, that are about to be negotiated under the title of New Pandemic Treaty and Amendments to the International Health Regulations. We are here today because we are all concerned by the World Health Organization's strong pressure to extend its powers, its structural and its financial capacities with a permanent effect over the sovereignty of the countries and over the self-determination of the people. It was in the wake of the COVID-19 crisis that the WHO has initiated a reform process which will bring significant changes to all of us. that will concern every human being and every of the 194 member states on this planet. This reform process was started in 2021 with two working streams, preparing two separate legal instruments. Number one, a complete new treaty, the so-called New Pandemic Treaty, and number two, significant amendments to the already existing international health regulations. These two legal instruments, treaty and IHR, are about to be negotiated and finalized, and they bring material changes. The contents of these drafts are on the table. They are available. They are available for everybody. And already in 8 months' time from now, in May 2024, the 194 member states of the WHO will have their final vote on both of these international agreements. This process takes place behind closed doors and at a tremendous speed. It is not reported nor discussed in our newspapers, in our national parliaments, in universities, nor in society. It is unacceptable. This is unacceptable because these two legal instruments will affect every one of us by reducing, even diminishing our loss, our right of self-determination, our right in general of human dignity, and it will eliminate the basic principle of democratic participation. Also, the effects of these treaties will be felt by member states. They will lose, who will lose their sovereignty and their autonomy. Therefore, every human being on this planet should understand the essence of the two legal instruments which come under the title of pandemic prevention, pandemic preparedness, and response. In a nutshell, the WHO claims in these two legal instruments an absolute and non-questionable leadership in all health matters as soon as WHO refers itself to pandemic prevention, preparedness, and response. WHO claims to have the ultimate expertise and the ultimate power in all aspects of this wide field. I recommend to read carefully the current existing draft of the amendments of the International Health Regulations, Article 13A and Article 42. It shall be granted the power of a massive self-authorization whenever it claims to act under this purpose. I recommend to read Article 12 that establishes the preconditions for public health emergency of international concern, together with Annex 2 of the proposed amendments. On the basis of an extremely vague concept, One Health, which basically means anything and nothing, animals' health, ecosystem, concerns about the level of CO2, and of course human health can give rise to permanent measures and even to a public health emergency, to a pandemic called out and declared by the WHO. And thereby, number 4, WHO has the right, will have the right to not only declare recommendations made by several experts, but also to impose on the people of this planet, or only to a certain region, all kinds of restrictions, access restrictions, lockdowns, surveillance, and experimental treatments. So far, the list of these potential measures can be found in the International Health Regulations, Article 18. And there you will also find one example of the precondition of the proof of vaccination. That was so far meant to be non-binding. In the future, as the word binding is eliminated, and as we have explicitly written down in Article 13a, the proposal, and 42 of the proposal, the commitment that the member states will give when they accept these amendments, the commitment that they will have to apply the proposed measures. This is not enough. Further, WHO will most notably reserve and assume the right to define as the sole instance on this planet and to control all information that it claims to be related to health. And this assumes as well the right for censorship and the right to interfere in social communication. It seems to be so important to the WHO that these provisions can be found in both of the international new agreements, in the international health regulations and in the new pandemic treaty. And last but not least, of a brief summary that should any time be given once we speak about these new changes, is the fact that there is no mechanism foreseen that will allow the people or the member states to challenge the assessment of WHO, whether it is the WHO's assessment about a public health emergency or their assessment with respect to certain measures, or when it comes to the imposing of a regime for what they call vaccination, as experimental as it might be. There will be simply no stop button for none of the member states, and not, of course not, for us, the citizens. So now, if we just look at it as a whole, this right of WHO to self-declare, to also auto-authorize itself to claim a public health emergency of international concern and to maintain it for as long as it wants. Number two, to issue so-called recommendations that will be legally binding and that will be subject to a system of surveillance of the people, surveillance of the member states, then the total control and monopoly on information, including the right of censorship, and then the fact that there is no mechanism of control, the control of WHO, and of correction. What do we have as a result? Well, it is very simple to say. Without the open and the open debate, without the possibility of having different opinions, different hypotheses, different methods to be discussed at the table, there will be no science. And there will be ultimately no democracy. And there will be no legal court proceedings and no justice. If the result is already predefined by one sole authority on this planet, there cannot be, by definition, a proper scientific process, a proper decision-making process. There cannot be any democracy. Number two, it is a basic principle not only of international law, not only of national constitutional law, that we have, as human beings, the right to know what we consent to. So if we ask ourselves, have we been asked, have we been informed about this process that is about to become reality? The answer is no. And there is one important distinction to be made between these two legal instruments. The new pandemic treaty will be considered by WHO itself as a treaty, and thereby shall be subject to a national process of debate and ratification. But not so for the international health regulations. The international health regulations, by definition of WHO's own writing, when you read the international health regulations, they are qualified as health regulations according to the WHO Constitution, Article 21. And what does that mean? As a consequence, there will be an automatic coming into force right after the vote in 2024. So far, it is still 24 months, but these 24 months have been reduced to 12 months only. So that means that at the end, after May 2025, the international health regulations will become law automatically. So we will not be asked, we have not been informed, and there will be a process of automatic enactment of the international health regulation. This is about as severe as it can be when it comes to the violation of the principle of an informed consent. This principle does not exist only on the individual level, but it exists only also for democracies as a whole. And it exists under the title of self-determination of the people, which is one of the founding principles of the United Nations in the United Nations Charter, Article 1 of 1946. Now, this is the reason why we should all get to know not only what is in these documents, but we shall claim and clearly say that some of these international health regulations and the changes that are modified and declared there will totally be opposed to what we consider our constitutional order, as there is no public information right, as there will be censorship, as there will be human rights not protected, as there will be no checks and balances, as actually it will be the WHO to determine under which legal status we will have to live. That means the power will not be anymore in the hands of the people. And therefore, these negotiations have to be stopped immediately, and it is a matter and a duty for all citizens now to impose the pressure towards their public representatives, political representatives, to make sure that the politicians, the political representatives, understand that they go on beyond of their entrusted vote they can use. Now, as this is just an overview, and as we are here in Europe, and as within Europe, these rules have been already pushed forward to an alarming extent, we found it important to provide you a more detailed overview on the situation here in Europe. And thereby, I would like to hand over the microphone and the stage to Dr. Renate Holzeisen. She will explain to what extent the EU has already widely anticipated WHO's project of power grip. Please, Renate Holzeisen.
Thank you, Philippe. And for this purpose, I have first of all to remind you of the following. The European prosecutor is investigating the COVID-19 vaccine deals of the European Commission's President, Ursula von der Leyen. Ursula von der Leyen is in a huge conflict of interest regarding at least all the decisions of the European Commission in the field of the biotechnology and the substances based on mRNA because of her husband's position and professional activity in that field. In the European Union, in the case of a public health emergency declared either by the WHO or the EU, it is possible to put on the market or in a conditional way also vaccines, so-called vaccines. Starting with 21st December 2020, the European Commission, on the basis of the alleged fake of a public health emergency of international concern declared in January 2020 by the WHO, and on the basis of the untruths that there was an unmet medical need, authorized as so-called COVID-19 vaccines, mRNA substances based on genetic engineering, under the condition that their efficacy and safety had to be confirmed by clinical trials. These clinical trials have never been conducted. and that these substances had no efficacy for the prevention of infection emerged from the beginning on, also from the assessment reports of the EMA. Although the efficacy and safety of these experimental substances have never been tested and proven, in the meantime, the European Commission gave them even a 5-year valid unconditional authorization. So, and on this background, we face not only a brutal violation of European pharmaceutical legislation by the EMA and the European Union Commission, which puts in life and which puts on a high risk life and health of 550 million European Union citizens. But the European Union is now going even to change the European Union pharmaceutical legislation, reducing the regulatory burden and providing a more flexible regulatory framework. This obviously in order to be able to put on the market experimental substances also for mass vaccination programs without any risk to be held accountable for violation of so far principles of the European pharmaceutical legislation. So we see an EMA and the European Union Commission, which in the last nearly 4 years committed already a criminal violation of the European Union pharmaceutical legislation by bypassing the legislation for the so-called advanced therapy medicinal products, defining clearly experimental gene-based substances simply as vaccines and putting them on the market for mass vaccination programs. So we have to remind that in June 2021, the European Parliament and the Council installed the European Union Digital COVID Certificate, which gave the so-called vaccinated, although there was no evidence that they couldn't transmit the virus, in contrast to the unvaccinated and the untested and the unrecovered, the possibility of free movement. The European Union digital COVID certificate was and is absolutely lacking in scientific evidence and a clear instrument of discrimination and a clear instrument for pushing the citizen to the so-called vaccination with experimental genetic engineering-based substances. The Council and the Commission are pushing for a worldwide, robust global health strategy. One of the core priorities of these two organs is enhancing the equity to the access to vaccines for a One Health approach, which tackles literally the complex interconnection of climate, environment, and animals with humanity, for a more effective disease surveillance worldwide, and for stronger international rules and cooperation mechanism on health. Well, this sounds very military. The Council declared a new global health order is emerging and that global governance will require a new focus to maintain a strong and responsive multilateral system with a WHO at its core. Consensus should be built through deepened cooperation through G7 and G20. And therefore, it wasn't a surprise that Mrs. Ursula von der Leyen pushed on last Sunday on the G20 in New Delhi the digital identity pass, asking especially the EU member states to reach the goal of 80% coverage within 2030. So the Council and the Commission also declared that there will be the need of a close cooperation with the private sector and the so-called philanthropic organizations. We see that the Council already concluded on vaccination as one of the most effective tools for preventing disease and improving public health. And the plan is to, the Council and the Commission invited the Member States to develop training opportunities, communication and social media training of the Member States to allow health professionals and health communication experts to become more versed in effective techniques and tools for countering so-called vaccine mis- and disinformation. This is the starting point. From that, the European Union and the European Union member states are negotiating the modification on the IHR and the new pandemic treaty. The Commission negotiates on behalf of the Union on matters falling within the Union competence, where the coordinated position of the member states is expressed by the presidency of the Council. From published documents of the Council results that there is the will of the European Union member states to address so-called misinformation and disinformation. And with a decision of March 2022, the Commission was authorized, as already said, to negotiate on behalf of the Union. And to the Commission, the Council gave instructions. And in these instructions, the Council declares that the Commission had to negotiate this new pandemic treaty and the modifications on the lessons learned during the COVID-19 pandemic. Regarding this, we have to point out that according to the data of Euromomo, the higher the COVID vaccination rates are, the higher is the excess mortality rate in the EU member states. The Council declared further in the instructions given to the Commission that as the exact scope of the envisaged international agreement is not yet known, it will revise the directives. So, regarding this point, we have urgently to ask formally what is the exact scope of the International Pandemic Treaty and the modification of the IHR, because in the directives, in the instructions given by the Council to the Commission, that is not clear. They are declaring expressly that they don't know the exact scope. This is very interesting. And the Council declared also in these directives that these two, that the pandemic agreement and international health regulation will be legally binding for the parties and so also for the European member states. So, the Council's conclusions of the meeting of 9 December 2022 point out the need, the declared need of the combating of vaccine hesitancy. And therefore, the Council welcomes the Commission's intention to closely cooperate with the WHO in the development of the global digital health certification network. And taking in account the developments regarding the update of the IHR. So we are learning from the documents of the Council and the Commission that they are seeing the developments and the modification of the international health regulation as something given. The Commission has also now the possibility to conclude prepaid contracts with vaccine producers and in exchange for the right to the result, which, as we saw with the COVID-19 vaccines, in case of inefficacy, is formally adjusted by the EMA. So, We have regulations by the European Parliament and the Council of November 2022, which is always calling the European member states to further enhance their cooperation with the WHO, and in particular under the International Health Regulation. And therefore, we see that they are working directly for an acceptance of what is planned for next May 2024. I'm concluding, reminding also the fact that the Council recommendation of June 2023 claimed all the European Union member states to continue with the issue of the European Union digital COVID certificate, which lack completely of scientific evidence, in order to pass directly to the system of the WHO of a digital vaccine passport. This is the development. This is what is currently happening on the European Union level, and I recommend you to have a deeper look on the members of the group of chief scientific advisors to the Commission, as there are several members who have strong relationship with the World Economic Forum. Thank you.
Thank you very much, Dr. Renate Holzeisen. Now we continue with Professor Michael Geistlinger. As I mentioned, is a retired professor of the international law at the University of Salzburg, and he will explain now that the EU had no competences for creating the European Health Emergency Preparedness and Response Authority, HERA. Please, Professor.
Thank you very much. Distinguished members of Parliament, ladies and gentlemen, by the EU Parliament's resolution of 21st October 2021 on EU transparency in the development, purchase and distribution of COVID-19 vaccines, the EU Parliament expressed its deepest regret on the lack of transparency from the Commission, the Member States and pharmaceutical companies. In addition, the EU Parliament asked for further measures providing transparency. In particular, it criticized the Commission's decision to refrain from using the ordinary legislative procedure through Article 168 TFEU in setting up the new European Health Emergency Preparedness and Response Authority, as HERA is called. The EU Parliament's concerns were more than justified. Whereas HERA should have become operative only in 2023, it became operative already on 8 December 2021, and is considered the core of the new European Health Union and Pandemic Preparedness and Response System. HERA places itself in the center of the argued EU's improved reaction to COVID-19 and in the efforts of the EU to become the leader in strengthening global preparedness for future health emergencies. HERA links its activities to the definition of serious cross-border threat to health by the respective EU regulation and profits from them. Serious cross-border threat to health means a life-threatening or otherwise serious hazard of health of biological, chemical, environmental, or even unknown origin. By referring to the EU Global Health Strategy of 30th November 2022, HERA considerably expands its mandate. This strategy addresses health as a global good being impacted by the triple planetary crisis of climate change, biodiversity, and pollution. By means of reference to regulation and strategy, HERA provided itself with superpowers in the area of health, embracing everything. Health combining climate change, environmental pollution, and even nuclear fallout. Looking at the first anniversary's report on the activities of HERA, I could give you a great number of examples how HERA expanded its activities and is indicating a further expansion in future. Just to mention one example, HERA obviously follows the proposal of the Special Advisor on COVID-19 to the European Commission President, Peter Payot, to replace the term COVID-19 booster vaccinations by seasonal vaccinations, like for influenza, and included influenza in pandemic, having concluded on 28 July 2022 a joint reservation contract for 85 million doses of pandemic influenza vaccines. HERA's announcement of the deal reveals its understanding of pandemic when it states, I quote, an influenza pandemic would be a global epidemic caused by a new influenza strain to which there is little to no pre-existing immunity in the human population. The contract is just the beginning, as HERA aims to expand inter alia on medical devices and laboratory materials. Let me thus please submit a question which could be handed over by the present members of Parliament to the plenary. Why does the EU Parliament silently tolerate whatever HERA does? But there are two other questions which are more complex and are very linked on the legal side to this first question. Why did the EU Parliament refer the EU Commission to Article 168 of the Treaty on Functioning of the European Union, TFEU, I will just call it, which, as all the other articles in the TFEU, do neither provide the Commission nor the Council, but I apologize, also not the Parliament, with any competence to adopt legislative acts in the context of a pandemic. Why did the EU Parliament agree to base legislative acts in the context of a pandemic on poor references to articles in the TFU and TEU using the word health, instead of verifying whether those articles do indeed assign the EU and its bodies the respective competence? Is not lack of competence worse than lack of transparency? As for the competence of the EU in health matters, the fundamental norm is Article 168(5). Besides adopting measures on the EU level as incentive measures, even when it comes to combating serious cross-border threats to health, no delegation of competences by the EU member states has taken place. The aim of achieving a high level of health protection laid down in Article 161(1) cannot overrule the limits to the EU by the same article. Union action is restricted to complement national policies, not to replace them. The EU member states are led to cooperation in between themselves, which cooperation shall be supported by the EU. Article 168(2) para 2 mentions guidelines as an example for a useful initiative to promote such cooperation, but not regulations, not decisions, and even not directives. The Council is expressly allowed to issue recommendations for the purposes set out by Article 168 TFEU. Legislative measures adopted in the procedure for ordinary legislation that reach further are restricted by Article 164 TFU to 3 matters: setting high standards of quality and safety of organs and substances of human origin, blood and blood derivatives, in the veterinary and phytosanitary fields, which have as their direct objective the protection of public health. And finally, setting high standards of quality and safety for medicinal products and devices for medical use. There is no provision in this Article 168(4) related to measures for early reporting, monitoring, and combating serious cross-border health threats, particularly in the case of pandemics. Thus, to use the instrument of a regulation based on Article 168(5) TFU must be considered overstepping the limits of competences of the EU bodies. The reference to Article 114 TFEU in the context of EMA, setting EMA within approximation of laws in the internal market, can only be understood as desperate effort to find any respective competence in the EU, which in fact is not given. Even if the protection of health is considered as cross-section matter according to Article 9 TFEU, which has to be considered whenever the EU bodies become active, according to the jurisprudence of the European Court of Justice, Article 114 TFEU must not be used to circumvent the explicit exemption from approximation of laws under Article 168(5), with the exceptions of Article 168(4). Measures to fight pandemics like COVID-19, even subsidiarily, cannot be based on the internal market competence of Article 114(1) TFU. Legitimate doubts may be raised also as to the current negotiations on the World Health Organization's pandemic treaty and a package of amendments to the international health regulations. In both cases, the EU has taken the lead at the pandemic through the European Commission, at the international health regulations through the EU presidency. It must be doubted that the strong negotiation power of the EU is in line with Article 168(5) TFU, which provides that, I quote, "the Union and the Member States shall foster cooperation with the competent in the international organizations in the sphere of public health." With regard to the World Health Organization, the EU has become active on behalf of its members and not in cooperation with them. Given the understanding of health as human health, as opposite to animal health, in Article 168(5) TFU, also the One Health concept of the EU, underlying its internal measures with regard to pandemic preparedness and prevention, and its impact to the negotiations of the pandemic treaty and package of the World Health, international health regulations, must be put into doubt as overstepping the limits of the EU's and, as a consequence, also HERA's competences. To enlarge the understanding of threats to health to also include environmental threats, thus cannot be based on Article 168(5) TFU, but must be in line with Article 191(1) TFEU, which is to be applied only in such a case. Article 109(1) TFU entitles the EU, however, only to adopt an environmental policy measure which pursues inter alia the object of protecting human health, and not a human health measure meeting an environmental threat. As far as reference is made to Article 35, European Charter on Fundamental Rights and Freedoms, the provision must be understood as not enlarging the competence of the EU and its bodies. It obliges them to pay due respect to this article when using their competences, inter alia under Article 168 TFEU. Since HERA is built by the European Commission on its own competences as to health, the lack of a legal fundament for the European Commission's and the EU's respective activities also leads to HERA's lack of legal basis. Focusing on the fight of pandemics leads to the fiction of a permanent crisis mode and the respective rearrangement of financial resources and personnel capacities. This makes regular health care in the EU member states suffer and detriments EU people. The EU Parliament is thus urgently requested to return to what it has been delegated to do by the EU member states and stop all EU bodies, in particular HERA, from continuing as to pandemics to act ultra vires. Thank you very much.
Thank you very much, Professor Michael Geistlinger. Now we come to Dr. Beate Pfeil. She will explain why the concept laid out in the two WHO documents, Pandemic Treaty and amendments to the new international health regulations, why this can lead to quasi-institutionalized human rights violations and or to a permanent undermining of the rule of law principle. Please.
Thank you. Dear members of parliament, dear ladies and gentlemen, I would like to begin with a quotation, which, however, must remain incomplete for reasons of time alone. Perhaps one or the other of you knows where it comes from. I quote, "We, the heads of state of government of the states, have assembled at a time of profound change and historic expectations. The era of confrontation and division of Europe has ended. The courage of men and women, the strength of the will of the peoples have opened a new era of democracy, peace, and unity in Europe. Ours is a time for fulfilling the hopes and expectations of our peoples have cherished for decades. Steadfast commitment to democracy based on human rights and fundamental freedoms." End of the quotation. Human rights and fundamental freedoms, indisputable core values of the states of Europe and the European Union. Has it been possible to fulfill the corresponding hopes and expectations in times of so-called pandemics? How are human rights usually implemented? Allow me to take a brief excursion into the doctrine that underlies the constitutions of the EU member states, as well as many international law treaties, such as the Council of Europe's European Convention on Human Rights, the United Nations International Covenant on Civil and Political Rights, as well as the Charter of Fundamental Rights binding the EU and its member states when implementing EU law. All people are free from birth and are endowed with human dignity. The state, or even the EU, can restrict this freedom for the public benefit and must even do so in order to protect other people. However, while people can exercise their freedom as they wish, interventions in personal freedoms must be justified by the state or the EU. The principle of proportionality plays a central role here. Accordingly, interventions in fundamental rights must serve a legitimate purpose and be suitable, necessary, and appropriate to fulfill this purpose. Measures with reference to public health must thus include a risk-benefit assessment on the basis of genuine scientific evidence. This can only be achieved through a free scientific discourse involving all relevant scientific disciplines. In a democratic state under the rule of law, there are mechanisms to ensure proportionality and other principles that are intended to protect the individual from unlawful state encroachment. These include the separation of powers and a system of checks and balances between these powers. Furthermore, encroachments on fundamental rights should only be possible by parliamentary act, and their legality must be subject to constitutional judicial review. Now, what about the adherence to these principles at the WHO level? Assuming the planned amendments to the International Health Regulations, IHR, and the new pandemic treaty were to be adopted in one or another form and subsequently enter into force. And how does the European Union contribute to compliance with these principles, to which it is itself bound by the Charter of Fundamental Rights? Especially since the EU Commission was giving a corresponding mandate to negotiate the planned WHO documents by decision of 3rd March 2022. To answer the first question, let us imagine the following scenario. We are in December of the year 2025, a fictitious state X. There is an outbreak of a seasonal infectious disease and begins to make its rounds. Step 1. Through the close surveillance mechanism for infectious diseases, the information reaches the WHO Director General, who decides on the declaration and termination of a health emergency. Article 12 IHR. The Director General can choose from a now extended list of rather vaguely formulated diseases contained in Annex 2 of the IHR, and in the course of the so-called One Health approach, which was mentioned here before, also include aspects of animal, climate, and environmental protection. He can then declare an intermediate health alert or already a public health emergency of international concern, so-called FAKE. The declaration of a mere regional emergency is also possible. Formally, the IHR provide factual criteria for declaring and terminating such fakes, including scientific evidence and risk of international spread of disease. Also, the expertise of an emergency committee is available to the Director General. Now, suppose the Director General decides to declare a fake. Does this ensure that there is indeed a dangerous cross-border global health emergency that could justify certain measures? Absolutely not. The reason: there is no independent body which could check the decision of the Director General in advance and correct it if necessary. The Emergency Committee, like all expert committees mentioned in the two WHO documents, is in no way independent, is appointed by the Director General, and its recommendations are not binding. I just recall the case of the monkeypox. Even State X has no longer any say in the matter, and the Director General can make his or her decisions purely arbitrarily. Step 2. The Director General can now trigger a whole cascade of obligations on the WHO member states by means of now obligatory so-called temporary recommendations. I call them more appropriately emergency orders. And at the same time, he receives executive power with regard to their implementation. Conceivable obligations are drastic measures restricting fundamental rights, such as orders for vaccinations, tests and corresponding proofs, vaccination certificates, medical examinations and treatments, regulations for travel and trade restrictions, isolation and quarantine, contact tracing, and comprehensive so-called lockdowns. All of this is based on the Articles 15 and 18 of the IHR and others. Here, too, scientific evidence and proportionality are formally demanded, but here, too, there is a lack of independent review bodies that conform to the rule of law. Here, too, the door is open to arbitrariness and thus to worldwide, comprehensive, and massive human rights violations. In addition, there are allocation plans, production obligations, and financial obligations for the so-called health products and pandemic-related products being produced by the so-called non-state actors. What a strange terminology. Especially vaccinations, whose effectiveness and principal harmlessness is thus already taken for granted. Due to the verifiable financial dependence of the WHO on the pharmaceutical lobby, this fact is highly explosive and above all suitable for sacrificing the actually inalienable human right to physical integrity to profit interests. Step 3 is also highly explosive, takes place in parallel and also independently of the existence of a fake. Here the aim is to combat so-called infodemics, another interesting word, consisting of too much, false or misleading information. At the same time, the population is to be specifically educated in the areas of science and public health and specifically guided in their behavior. We call this nudging. There will be an expert later on speaking about such kinds of patterns. The problem, as a rule, there are no incontrovertible truths, also in the field of natural sciences, and especially when it comes to the proportionality of freedom interventions. There is an urgent need for a constant and independent scientific discourse in the spirit of at least approximating scientific evidence. In particular, free and informed consent in physical interventions is only conceivable on this basis. However, it is precisely here that the WHO arrogates to itself an uncontrollable monopoly of truth, which threatens the freedom of science and teaching, the freedom of opinion and information, and the freedom of the media, and paves the way for comprehensive censorship. This undermines the social discourse necessary for democracy and the rule of law, as well as the scientific discourse and the role of the media as a further control authority for state power. Ultimately, the values and foundations of democracy and the rule of law are acutely threatened, and a dangerous form of totalitarianism is on the horizon. In sum, the new WHO rules establish a regime that creates a virtually insurmountable tension with the constitutional and international legal obligations of its member states, and thus threatens to undermine the principles of human rights, democracy, and the rule of law. This is all the more so because the WHO is given quasi-legislative powers here through the binding so-called recommendations. In fact, they are orders, and at the same time acts as an executive which is equipped with conspicuously strict implementation mechanisms, potentially including sanctions, and which deprives itself of any independent control. This is capable of exerting immense pressure on the individual states, which, especially in the case of a fake, are thus left with virtually no time or leeway to remember their own constitutional rules of the game. And the latter has already become visible during the COVID-19 era, even without that pressure from the side of the WHO. The human rights violations and damages caused are already immeasurable, as the colleagues will point out. And the question why must still be allowed. In conclusion, I would like once again to give a voice to the governments of the OSCE member states, which also include the EU members, specifically in the 1990 Charter of Paris for a New Europe, supposing to usher a new era. I quote again, "Human rights and fundamental freedoms are the birthright of all human beings, are inalienable. Their protection and promotion is the first responsibility of government. Respect for them is an essential safeguard against an overmighty state." In which era are we currently? It is up to us, every single person, every person in positions of responsibility, whether at state or EU level, to make a decision. Let us speak out here and now against overmighty states, an overmighty WHO, and also against an overmighty European Union, which, as colleagues have shown, has already set itself on the path to establishing a WHO-like regime. The task is to prevent this in the interest of safeguarding hard-won European values, first and foremost, human rights. Thank you.
Thank you very much, Dr. Beate Pfeil. Thank you very much to my dear colleagues. Now we come to the second part. May I ask to come up to the floor the experts for the second round. Please welcome with me with an applause. We have here Dr. Maria Huber-Mock, Professor Andreas Sönnigsen from Austria, Dr. Peter McCullough from the United States, Professor Matthias Desmet from Belgium, and Dr. David E. Martin from the United States.